Hello, part 2. Part 2 has a title of this: Legal Rules Regarding Consumer Credit Agreements and Agency. This area of business law relates to consumer payment for goods or services being either buy now and pay later, or payment being spread over time, such as monthly instalments, or both of these options together. This is usually made available by the seller when the item or items to be purchased are what is known as high ticket or expensive items, such as, for example, a new motor car. The item can be purchased by the consumer via use of an independent loan or through use of a credit card. Whichever option is taken will involve a consumer credit agreement and be regulated by the Consumer Credit Act 2006. The key financial data involved here are as follows: the loan amount, the charge for credit, the total amount payable, the monthly instalments, and the APR, which is the annual percentage rate. All of these considerations relating to the loan need to be known by the consumer before they agree to it and sign up. Indeed, there is now what is referred to as a cooling off period, normally 14 days, to allow them to change their minds even after they have signed up. This cooling off period is particularly important if the consumer has entered into the contract at a distance. So what does that mean, at a distance? Well, it could be they've agreed over the telephone, they've done this arrangement, this agreement by use of the internet, through the post, or through use of an intermediary such as a broker. There are many offers made, such as 1. Pay nothing until a certain date, usually in 12 months' time. This simply means that payment is lumped over the final 4 years if, for example, it is a 5-year contract. Or 2. Interest-free credit as advertised. This allows the consumer to pay back the outstanding balance within a specified period of time. However, if they fail to do so, the balance of payments due will simply roll over into a longer-term credit agreement, and this will, of course, include interest charges to be paid. Agency. An agency is defined as follows: a consensual relationship created by contract or by law where one party, the principal, grants authority for another party, the agent, to act on behalf of and under the control of the principal to deal with a third party. The law of agency does allow one person or one company to employ another to do their work, to sell their goods, to acquire property on their behalf. And if the employer were present, as if the employer were present and acting in person. However, on occasion things do go wrong and problems may then occur. Example 1. If a self-employed driver agrees to use his truck for delivery purposes for another organisation, and in doing so is involved in a road accident, which leads to a pedestrian being injured, who does the pedestrian sue for damages? It is likely that he or she will be able to sue the organisation that hired the truck driver, as they are the employer in a principal-agent agreement, with the driver being seen in the eyes of the law as simply the agent, who has been authorised to act on behalf of their employer, the principal, and as such will be deemed liable. Example 2. An advertiser uses an advertising agency to create an advertisement and then negotiate to place the advertisement in the media. However, after the advertisement has appeared and before payment to the media, which is normally 28 days later, has been paid, the advertiser goes bankrupt. How would the media obtain the outstanding payment when it becomes due? Here, the media would be in a position to claim payment from the advertising agency, despite the fact they would know full well that the advertising agency will be unlikely or unable to claim any money from the principal, the advertiser, despite having done work for them. This is because in English law, an advertising agency acts as a principal in its own right and is liable for payment to the media, whether it is able to actually claim reimbursement from the ultimate principal, the advertiser, or not. This is because it negotiated the space or airtime with the media in its own right, under its own name, and subsequently issued an order to the media owners using its own name, address, contact details and logo together with a signature. The media needed to receive this before allowing the advertisement to appear.